We're just going to ask a question each and down the line. I don't know if you've been in hearings of ours before.
I have, yeah.
Yeah, great, excellent. I was very interested in your submission, Mr. Kerin. You were pretty supportive of the bill,
yes,
based on some experience you've had with owners corporations, and it looked like you'd had the benefit of reading some other submissions, and you seem to think that the bill had struck the right balance in terms of being consistent with laws and other jurisdictions and appropriately allocating risk. Have I got that right? Is that your general feel about this bill?
Well, I should have said one other jurisdiction, that's New South Wales.
Yeah.
So parts 6 and 7 of the bill basically are very close to the Residential Apartment Building Act in New South Wales. Mm-hmm. So the rectification order provisions, the enforcement provisions, they're very closely aligned. The provisions in relation to statutory warranties and making developers liable for breach of statutory warranties is the same as New South Wales. It's been like that in New South Wales for decades. So there's nothing unusual about that or different. I know Victoria is also apparently looking at that now. So there's nothing. And in Victoria and Queensland, they're also looking at accreditation schemes for developers as well. So this bill goes a bit further than certainly what's being envisaged in Victoria and Queensland, and also it goes further in some aspects than what's currently provided for in New South Wales. But that's not necessarily a bad thing.
And this bill, it does a number of things, but it essentially makes the accountability and risk for property development sit with the property developers. What's the harm that you've observed in the absence of this bill? What harm have you seen over the last decade of your practice without having that accountability and risk?
Yeah, so developers usually structure their affairs to avoid responsibility for things. I mean, currently in the ACT, the only way you could possibly sue a developer for building defects is if they have a contractual warranty in their sale of land contract. So there's a warranty that says that they've done the work very well and with good materials and so forth. And so a lot owner might be able to sue a developer for breach of that contractual warranty. I was acting for some owners who did that some years ago, and we successfully got money from a developer, but the developer didn't expect it, hadn't anticipated it, because they thought that there wasn't going to be a problem. Since then, I've not seen provisions like that in sale of land contracts. I think they've kind of not put those sorts of contractual warranties in. There's also, secondly, the possibility that a developer might be liable for implied warranties under the Civil Law Property Act. But again, I know of at least one large law firm in ACT that structures the selling contracts in a way to avoid that. So basically, it's very hard to sue developers for defects. There's really only two ways, and both of those ways have been addressed by lawyers acting for developers.
Sure, so do I. I'll have one further supplementary. Given the negotiating power between a developer and, for instance, someone who's buying off the plan, and given the current state of the market, do you think most prospective buyers would be able to negotiate the types, would they know about the types of contractual clauses, and would they be able to negotiate those into contracts, or do they need this kind of regulation to protect them?
Most purchasers wouldn't have a clue. They're really focused on European kitchen appliances and things like that more than what warranties are in the contract.
Sure.
So most people are simply unaware of it. So there was a second part to your question.
Given the negotiating power they have in the current state of the market, if they were aware of it, would they be able to put that kind of contract clause?
I'd suggest not. The contracts are pro forma. Each of the law firms that acts for the developers have their own kind of bespoke sale contracts with their own clauses. If you might ask for an amendment, whether you get it or not is another question. It probably depends on the market conditions. But I'm not a conveyancer. I've never done conveyancing in the ACT, so I can't speak from experience in these matters, but I'd be surprised if it was happening.
Yeah, beautiful.
Thank you. Mr. Kerin, just picking up on some of the comments you've made about the ways that people can take legal action to get rectifications and looking at being contractual under warranties, how hard is it, or what's the threshold for actually proving that the product used weren't of good quality or that there was poor craftsmanship that's actually led to the problem for someone who's taking action against a developer?
It's expensive. If that's hard, then yes. The difficulty is you've got to get an expert to come in and look at what's happened. And so it takes time because, unfortunately, even though developers are required to give the owners' corporations the plans and specifications at the first meeting, it actually doesn't happen a lot. And so even though they're required by legislation to give you the documents, a lot of developers simply don't comply with the legislation. So you're starting from scratch. You don't even know, you don't even have those things. You've got to go and get the building file from Access Canberra, give that to the expert. Hopefully that accords with what's actually been built, and then the expert's got to go out and work out what's happened. So there's a long process there, which is expensive. And so it is difficult. And then, of course, there's always pushback from the builder developer. There are games that they play in terms of, wearing out or drawing the process out, looking like they're coming back and doing work, but not taking it very seriously. That buys time, trying to drag you beyond the 6-year limitation period. There's common tactics that are used by builders in this regard.
Okay. And because we're looking at property developer licensing and you've mentioned builders, do you think there is enough accountability for developers in the process? Because we've had a number of submissions, particularly from industry, saying it's unfair to signal out the property developer, that there's a lot of other people who are responsible for the work and they should have the responsibility for rectifying. So I'm interested in your experience in looking at where you have taken action. Is there a need to bring developers into the picture and to put more accountability on the actions that they're taking, given that there is a range of players in developing a building or delivering a building?
The interesting thing about the bill is that it doesn't do anything to a developer that isn't already being done to a builder. A builder's already personally liable potentially for rectification orders. The builder is already liable for statutory warranties. The builder already has to be licensed. Like, all of these things already apply to builders, but they're simply applying to developers. Shouldn't be controversial, I wouldn't have thought. In terms of, so the other part of your question was?
I think that answers it. I think the other part I'm going to is more the relationship between the developer.
Oh yeah, that's right. Yeah,
builder.
It's a complete furphy to say that somehow developers are remote from the process. That really they're vulnerable to the actions of consultants and builders in terms of the way they go about the job. The reality is that the developers are completely in control of the process. They can determine how much design is done on a project or not. At what point, what sort of consultants, reputable builders, where corners might be cut, doing deals with, people to, making special arrangements. Let's just leave it at that. So, I mean, developers are right in the thick of it. The idea that they somehow come to these things with clean hands is I think, can't be a serious idea.
So, Mr. Kerin, I'll finish up. Mr. Kerin, is it fair to say that, sorry, I lost my train of thought because of the interruption. Mr. Kerin, is it fair to say that because developers do have a part in, because builders are liable have personal liability in the defects, but because developers have such a role in influencing the decisions they make, that it's almost an unfair system at the moment, that the builders are taking on a lot of responsibility for the developers?
It's certainly unfair if you look at it from New South Wales' point of view, where it's equal liability. A developer is equally liable for breaches of statutory warranties as a builder. So in Canberra, they've just had a free run, basically, which has always puzzled me a little bit. Whether something's fair or unfair, that's not really a legal question, it's a subjective question, but it's probably a bit unreasonable, yeah.
Do you have a short substantive? Or?
I do. Just quickly, just with the reversal of onus of proof in 89F, a few people have raised that it's not quite fair how this section is working, and I don't know if you've got the bill in front of you and know.
I'm aware of the provision.
Yeah. Do you have any views on that you'd just briefly like to share with us as to whether legally you think it's fine or not?
The thing is, Owners, so who's in play here? Typically this is builder versus, really now builder developer if the bill goes through, versus apartment owners, housing owners. Now, these owners know nothing about what's going on in building work, right? And so typically when something is eventually raised, and this is not something that owners aren't looking for problems, they don't want to spend time on these issues. It has to be bad for an owner to be motivated sufficiently to reach out to the builder and get things fixed, right? And the immediate response is always, you haven't maintained the building, that it's wind-driven rain, it's not a design issue or a building issue, that somehow the owner's done something that's caused the defect. These are common responses that I hear from builders and developers. So the reverse onus is helpful in terms of avoiding that sort of nonsense counter-argument, which basically wastes everyone's time.
Mr. Barton.
Yes, Mr. Kerin, in your submission, and I think it's really important that you've led us to this, you express frustration with the new framework around the residential building dispute administrator, and you've done so because it's clear that this bill, if it's passed, it'll be necessary to have a bureaucracy in place to administer the Act.
Yeah.
I was just walk me through, if you could, the frustration that you have with the fact that the residential building dispute administrator framework is something that's been flagged now for a long time, but is clearly not in place.
Yeah. Well, the bill is fine, and if it's passed, fantastic, but you actually have to have people to administer the bill. And so the people, at least some of the people who have to administer the bill, have to have some knowledge, technical knowledge of the building process. And I don't know quite why the residential building disputes scheme has not kind of actually, I mean, it's in force, but it's not actually there. I suspect it's because they can't find the technical people in the jurisdiction to administer the Act. And so it raises the question, I mean, it's great to have an Act that does things, but if no one's there administering it, it's pointless. So it's a very unusual situation, I might say, to have legislation passed that creates a scheme and then there's no one administering the scheme. It simply doesn't operate. So I just wonder how that's going to work in this situation, because you have yet another layer of bureaucracy.
So, despite your optimism regarding the bill as it stands, do I detect some pessimism in terms of the outcomes? Ultimately, if indeed we end up going down the same path as the residential building dispute administrator, and there's no one in place to actually...
Well, I can see a problem. Yeah.
All right.
I have a quick sup in the 30 seconds we have left.
Yep. We've actually got a little bit more time.
We've got 6 minutes.
Oh, we've got 6 minutes.
Yeah,
Great.
crazy.
I've just cracked all the time today.
Yeah.
Just on the note of the dispute resolution, we've had a few submissions suggest that actually we don't really need property developer licensing, we just need to get that up and running. Would you agree with that view, that it needs to be a one or the other, or is there a place for both?
So licensing or
the dispute resolution that we've just been talking about?
Oh, that. Well, they're not the same thing. This Act will bring in... I mean, the reality is some builders simply, for whatever reason, don't have any money and go under. And so in New South Wales, you always kind of pivot to the developer as well. There's a backup plan, as it were, because most buildings now are large and above 3 stories, so there's no insurance. And so it's either the builder or if the builder goes under and there's no rectification order, and rectification orders are not a given, they're not issued like confetti, they're rarely actually ordered by the registrar, the Construction Occupations Registrar. So then with this bill, you've got a developer that's sitting there, right? Now, the other thing about that is a lot of developers I couldn't give you a percentage, but a lot of developers use special purpose vehicles, so there's not necessarily money there anyway. So the bill firstly enables action against the developer, and then secondly, hopefully will enable there to be money behind the developer, either through the director or through an insurance program or whatever it is. So I think it's helpful in that regard.
Thank you. Mr. Kerin, we've had a number of submissions asking for exemptions to property developer licensing and to some of the protections. Specifically, people have asked for exemptions for community housing, retirement villages, and build to rent. Now, one of the witnesses said that there'd been no major defects in retirement villages construction. I didn't see any evidence about risk in community housing or build to rent. But have you had any experience, or do you have any views about whether certain types of building in those categories should be exempted, or whether they should comply with the same requirements?
I've really got no views. I've never acted for any of those entities in the ACT or New South Wales, so I'm not familiar with the problems they might suffer or whether they're endemic or not. So I can't really make any comment on that.
No, that's okay.
I mean, I might say, just as sort of gratuitous comment, the idea that this is going to cost more money in terms of the product, the end product. I mean, Ross Taylor, who is a waterproofing expert, who's worked closely with the New South Wales Building Commissioner, who's very involved in the next iteration of the Building Code of Australia, he's indicated that for every dollar not spent on design, that results in $30 in repair later on. So whilst this argument that the product is going to be more expensive, well, I think in the medium term it's not actually, because people have got to fix the defects at some point when they realise there are defects, and it's actually more expensive to fix it later on than to have gotten it right in the first instance and have that additional cost worked into the sale price. So I think that's a bit of a furphy in terms of, you know, the panic.
We've certainly heard that case made by a number of people that there's a cost somewhere, and the notion that the cost of licensing and compliance would be higher than the cost of avoiding the problems in the first place, and the fact of where those costs are borne is quite...
The longer it goes on for, in terms of the failure to rectify, the more likely it is that the owner is going to be paying. That's just the reality. So,
excellent.
I have a quick stuff just on the cost.
Sure, very brief.
Just with the cost, Mr. Kerin, would it be right, would this to be of the view that if developers and builders were building appropriately, there wouldn't be the defects, and so therefore the only cost that's going to be put on people is those who are not doing the correct thing in the first place?
It's very common for for developers not to do detailed design development. So they do the minimum design. I mean, I've kind of indicated in the submission. They do the minimum design in terms of getting development consent and so forth. But then the detailed design that you would normally do to make sure that all the various consultants' designs align, that things are developed and design is not done on the run or delegated to subcontractors and people who aren't really skilled in doing it. So that's the problem, you know, and if a bit more money is spent on that design development process, yes, it might cost a little bit more money in terms of the product, but you're saving huge amounts of stress and money and time later on the track.
So
Thank
really
you. We're at the end of our session now.
Sorry, I'm not sure I answered that question, but yeah.
I'm so sorry. We've got a lot of people to see. Thank you so much for coming in.
Thank you.
Please, if there's anything else that you did need to tell us, you are welcome to put in a quick written statement.
Are you happy to take some questions on notice, Mr. Kerin?
Sure.
Thanks.
Yeah, great. And we will lodge questions on notice within 5 working days. We will lodge those within 5 working days, too, if we have them. Thank you very much.
Thank you. Cheers.